So this is the UK delegation on the interpretation of contract. We are going to talk first with an overall introduction of interpretation of contract, the English law, the Scots law, and follow up with the interpretation in the UK, including general interpretation, gap filling through default rules, ad hoc gap filling, and contra-preferential rule, good faith, and then comparison with a Scots law and a situation in a Scottish law. And then we will finish with a comparison to the French and German legal systems. First of all, introduction. So interpretation must be directed at ascertaining what the parties have intended with it, not at what the court or anyone else finds the most fair, suitable, or efficient interpretation. In other words, interpretation of a contract is a search for a common intention of the parties. There are two main ways in order to interpret a contract. The subjective interpretation is to give preference to the real intention of the parties, since the words the parties used are only an expression of their intention. It is this intention that should prevail. The opposite view is to give a priority to the declaration and therefore to the external expression of the intention. English law is a common legal system governing England and Wales and is a part of UK. English law has no formal codification, and a decision of a Supreme Court of the United Kingdom, the highest civil appeal court of the United Kingdom, is binding on every other court including Scotland and Northern Ireland. Some rulings are derived from legislation or acts of parliament, others from a common law and case law are based on precedent. Hence, we can find two sources of law. The Scottish law is a mixed legal system, using a combination of both the elements from common law and civil law. Together with English law and Northern Ireland law, it is one of the three legal systems of the United Kingdom. Scots law recognizes four sources of law: legislation, legal precedent, specific academic writings, and custom. Legislation affecting Scotland may be passed by the Scottish Parliament, the United Kingdom Parliament, the European Parliament, the Council of the European Union, and the United Nations. Scottish Parliament is its main legislative body, whose competence encompasses all areas of law, except those expressly reserved to Westminster, as detailed by the Scotland Act 1998. Scotland Act 1998, which is an act of UK Parliament, has been further amended in 2012 and 2016 with the aim of devolving further powers to Scotland in accordance with the recommendations of the Kalman Commission. European Union law applies in the same way to Scotland as it does to England by virtue of Scotland's position as a constituent of the United Kingdom. Treaties, regulations, directives and decisions of the CJEU all impact Scotland. When the EU issues a directive on a subject which Scotland has responsibility for under devolution, Scotland will implement it itself. Scottish Parliament has a competency to legislate in the area of private law, including the law of obligations.
Now, interpretation in the UK. The general interpretation in English law, more specifically. First, in 1911, in the case Lowell and Christmas Ltd. And Wall, it was held that it was the duty to the court to construe the document according to the ordinary grammatical meaning of the word used therein. However, this approach has been abandoned, therefore the objective approach. Today, from the Investor Compensation Scheme Ltd. And West Bromwich Building Society of 1998, interpretation is the ascertainment of the meaning which the document would convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation which they were at the time of the contract. The civil law takes as its starting point the contracting parties, while England adopts the perspective of a reasonable person in the position of the contracting. Gap filling through default rules are standard solutions for problems typical to a certain type of contract. In common law, it exists terms implied in law. The leading case is the Liverpool City Council and Irwin. The implied term arose as a legal incident in contracts of a defined type between landlord and tenant that the landlord was to take reasonable care to maintain the common parts. Another way is through ad hoc gap filling. Once it is established what is proper meaning of the words used by the parties, the contract can be still incomplete. This is because it can never provide for all eventualities. The method ad hoc gap filling means that a lacuna in a specific contract of the two specific parties is filled with terms that are necessary for the working of the contract and that the parties would have agreed upon if they had thought about it. English law does not regard this as a means of interpretation. Instead, it speaks of terms implied in fact. English courts have adopted two tests to find the unexpressed intention. The first is often called the officious bystander test and was formulated in the Mackinnon LG in Charlotte and Southern Foundries. Prima facie, that which is any contract is left to be implied and not to be expressed is something so obvious that it goes without saying. So that if while the parties were making their bargain, an officious bystander were to suggest some express provision for in the agreement, they would tacitly suppress him with a common of course. The second test is called business efficacy test. The leading case is Moorcock. In this case, the defendant should warn the plaintiff of the uneven of the riverbed so that the boat would have not been damaged. Section 7.2 of the UK Unfair Terms and Consumer Contracts Regulation 1999 provides that a seller or supplier shall ensure that any written term of a contract is expressed in plain, intelligible language. This is the contra preferente rule. Paragraph 2 tells us that if there is a doubt about the meaning of a written term, the interpretation which is most favorable to the consumer shall prevail, but this rule shall not apply in proceeding brought under Regulation 12. This comes from a European directive, and therefore all the countries in the European Union should have transposed this directive. In England, there is no general principle of good faith. In fact, in Walford and Miles, the concept of good faith is repugnant to the position of the parties involved in the negotiations. Each party needs to take into consideration its own interests, so long as he avoids making misrepresentation. English law is more oriented into the economic efficiency, while the civil law ranks solidarity higher. English author Roger Brownsworth sums up various arguments against good faith. It will go against the individualistic principle and liberal ethic of English contract law. Furthermore, good faith is too vague, there is no legal certainty, and all contract does not have the same content.
The Scots law takes the similar approach, but it has slight differences. The general rule of Scots law interpretation of contracts is that the pursuit of the parties subjective rather than their objective intentions. Additionally, Scots law gives less attention to importance of contra preferentiam rule, and while it is not excluded, it is also not explicitly codified, as it is expected to be implied by the existing case law and legislation. The proposed special rule for contract interpretation was that any expression forming part of a contract and used by one party in a particular sense, whether or not used in that sense by any other party, should be interpreted in that sense if every other party at the time of contracting knew or could reasonably have been assumed to know that it was being used in this sense. The appropriate case law is Houtsworth versus Gordon Cumming. When interpreting a written contract, the court in Scotland is concerned to identify the intention of the parties by reference to what a reasonable person having all the background knowledge which would have been available to the parties would have understood them to be using the language in a contract to mean. This is a quote from Lord Hoffman in Chartbrook versus Persimmon Homes Limited, a case from 2009 that comes from United Kingdom House of Lords. Hence, the UK case law is also used for interpretation under the Scottish jurisdiction. Up until 2009, House of Lords was the highest appeal court in United Kingdom and hence also implied the case law over Scottish jurisdiction. It does so by focusing on the meaning of the relevant words, in this case clause 3 subsection 2, of each of the titles of the 25 leases mentioned in a case in their documentary, factual and commercial context. According to the court, that meaning has to be assessed in the light of: first, the natural and ordinary meaning of the clause, following with any other relevant provisions of the lease, then the overall purpose of the clause and the lease, then the facts and circumstances known or assumed by the parties at the time that the document was executed, and commercial common sense with disregarding subjective evidence of any party's intention, the latter being in accordance with the Contract Scottish Act of 1998. In this connection, the following cases are of pivotal importance: Reardon Smith Line Limited versus Ingwer Hansen Tangen, and Bank of Credit and Commerce International versus Ali.
The tension between giving priority to a party's subjective intention and to its objective declaration is clearly visible in the great codifications of private law. First, French law. In fact, according to Article 1156 of the French Civil Code, it requires the court to find the common intention of the parties, but also prescribes that unclear terms should be interpreted according to the meaning of the contract and the usage. Article 1160. With regards to Germany, this tension can also be found in section 133, that the aim of interpretation must be to ascertain the real intention, but it continues with Article 157 with the rule that interpretation should take place in accordance with fairness and reasonableness, taking into account general principle. Thank you.